Do privacy laws and regulations apply to small businesses? That's what we're going to be talking about in this edition of Privacy Awareness by Privacy Proficient.
Privacy Proficient.
Privacy laws and regulations do apply to small businesses. It could be just one person with one transaction for a small business to have a privacy law or regulation apply to that small business. Now you may be saying, well, that's ridiculous. That's not fair, but it happens. Let me give you an example. Under the GDPR, and there are different levels of this and different regulations, but under the GDPR, there's a documentation requirement. And it talks about if you have 250 people or less, you don't have to document things. Document things like consent and how it was procured, when it was procured, that sort of thing, whether it was withdrawn. Well, you do have to do it if there's risk to the data subject's freedoms or rights. Not high risk, can be any risk. And freedoms and rights are very broad. So that immediately puts a lot of companies who have less than 250 employees into the obligation to document things. So a lot of privacy laws and regulations can apply to small businesses, even though they don't meet some level that's set out in the law. At the end of the day, privacy laws and regulations apply to small businesses. Now let's take a look at some examples of how laws and regulations regarding privacy can affect small businesses. From a global point of view, there are many laws and regulations that apply to small businesses related to privacy. For example, the GDPR makes no distinction on the size of a business. Basically, it applies to any business doing business in terms of offering goods or services, for example, to people in data subjects, what they call data subjects in the European Union. So take a look at your website. Do you have different languages on your website? Do you offer to allow payment in euros? Do you actually sell goods or services to people in the European Union? Have you shipped goods to the European Union? You have to look at things like this. Do you specifically call out offers to people in different countries in the European Union? Any of those things are evidence that you are offering goods and services to the folks in the European Union. And it's no excuse that you don't intend to. If people are buying things from the European Union, then you may very well be subject. Another example is the Canada anti-spam law, the CASL. That applies to anyone who's marketing to folks in Canada and requires an opt-in. Another example is the Australian Privacy Act, which exempts businesses with less than $3 million of annual turnover, but then it has specific categories where it does apply. Things like health service providers, small businesses that relate to residential tenancy databases, contractors with the Commonwealth, and anti-money laundering. So this is the kind of thing where you, even if there are exemptions for revenue, there may be specific categories that pull small businesses in. And these are just examples. There are many laws globally in effect now and coming into effect more every day. So if you're a small business and you're doing business globally, it's a good idea to do a review of where you're doing business and what might be applicable to you. The California Consumer Privacy Act, effective January 2020, does make a distinction based on three different factors. One is revenue, 25 million or more, and a lot of annual gross revenue. A lot of businesses don't have that amount of revenue, or deriving greater than 50% of revenue from selling personal information of consumers. A lot of businesses don't do that. But the third element that will capture a lot of businesses under the CCPA is possessing personal information of 50,000 or more consumers. Now, a lot of businesses might say, well, I don't have, say, 50,000 customers or their email addresses, But you don't have to. All you have to have is personal information. Remember, things like IP addresses are personal information. So if you've got people visiting your website on a daily basis, that can add up. So 50,000 divided by 365 is about 137. If you got 137 people visiting your website every day, you might be subject to the CCPA. So is your small business doing business for a larger company? Well, then it may be subject to laws and regulations because it's doing business for the larger company. So this is commonly an example where a small vendor or a processor or even a consulting company is doing business in terms of data processing for a larger company. Consulting companies, for example, often take spreadsheets from larger companies and do analysis, as an example. If that data is personal data, and oftentimes it is, say marketing data being analyzed for the larger company, and the larger company is under regulation, then the smaller company has obligations also. This often plays out in terms of contracts, contracts between the two companies, which will spell out the terms. And the larger companies are increasingly required to vet small companies, oblige the small companies through contracts to things like security processes, do audits or have audits available so that the larger company can make sure the smaller company is doing what needs to get done. But it's also important for things like data breaches. Let's say you have a small company and one of your employees loses a laptop or a cell phone on which they had personal data that they were using to do the marketing analysis for the larger company. Or a DSAR, a data subject access request. So this is something where a consumer of the larger company comes and says, delete my data, and there happens to be a row of data in a spreadsheet that you're analyzing for the larger company that belongs to that person who demands the deletion. So these have to be gone through the correct procedure, and so the larger company may have obligations to do that, and since they do, the smaller company, your company, if you have a small business, may have that obligation to make sure that that gets done. In the United States, there are many sectoral federal laws that can be applied to small businesses. For example, COPA, which is a law that protects children and online privacy, CAN-SPAM, which is a marketing law regarding email, the FTC Act that protects against false and deceptive acts or practices. These can be applied to smaller companies. So there's not clear distinction a lot. And then there are dozens, probably hundreds of federal laws, in many cases related to privacy of personal data that can be applied to smaller businesses. If you're a small business, what's the number one question you have about privacy laws and regulations? We'd like to know. We'd like to hear it because in future videos, we'd like to address what's most important to you. So please put your questions in the comments sections or let us know through social media. What is your number one question about privacy related to your small business? Thank you for watching this edition of Privacy Awareness by Privacy Proficient. Please comment on this video or post any questions that you might have below. Also, click like if you've liked what you've seen, and please subscribe to our channel so that you don't miss future episodes. Finally, please share this in social media or with friends or other business associates or others who might benefit from this video. Thank you again, and we'll see you next time on Privacy Awareness by Privacy Proficient.
Privacy Proficient.